Thank you. I've been talking about new laws and writing this publication, which grows every year since 1989. And the reason it's so long this year is I did include all the provisions of all the 5 propositions that affect law enforcement. So if I hadn't put that in there, it would be shorter. So this year we saw a total of 900 bills become law, 893 regular session bills, and 7 extraordinary session bills. The governor vetoed 1,059 were sent to his desk. He vetoed 159 for a 15% veto rate, which is pretty much around his normal, this governor's normal average. What was interesting this year is that 2 bills became law without the governor's signature. And I really can't explain that. One was Senate Bill 254, which put Proposition 59 on the ballot. That was the one asking for voters' opinion on whether California's officers should seek to overturn the Citizens United decision by the U.S. Supreme Court that had to do with campaign finance. So he let that one become law by just letting it sit around rather than returning it with a veto. And the other one that became law without the governor's signature was SB 1182, which created 2 new felony crimes having to do with possessing certain drugs with the intent to commit sexual assault. There were what I thought were 3 main themes for this year. One was, or is, the decriminalization of conduct by minors. And it really struck me when I finished writing the digest how many things minors can do now and not be held liable criminally. Loitering with the intent to commit prostitution, Penal Code 653.22, now no longer a crime for minors. Prostitution, 647B, no longer a crime for a minor to engage in. Penal Code 640, fare evasion, only administrative penalties, no more infraction crime for minors. And of course, marijuana, anything that a minor does after Prop 64 was enacted relating to marijuana, whether it's selling it, possessing it for sale, cultivating 1 million plants, or whatever, is an infraction, only punishable by a few hours of drug education and community service. The other big theme was human trafficking. A lot of things in this area, including a procedure for human trafficking victims who committed crimes to get their records sealed, affirmative defenses for human trafficking victims who committed a non-serious, non-violent felony because they were coerced into doing so or feared harm, a new evidence code section allowing expert testimony about the effects of human trafficking on victims, and Penal Code section authorizing courts to prioritize human trafficking cases over other criminal cases. Then the next big theme was shielding criminals from deportation. We'll talk about a government code section, we'll talk about Penal Code 18.5 and Penal Code section 1473.7, allowing folks to bring a post-conviction motion for relief on the grounds of adverse immigration consequences. So those are the 3 big themes. A lot of great stuff in here for criminals and their attorneys. I had a local defense attorney email me right before Thanksgiving as I was struggling to finish this, and he said, "Kathy, I'm really interested to see the legislative digest this year." And we laugh about it every year because I do a training session right in this office every January for all the local defense attorneys who want to come. We share this work with them. There's nothing that's a secret here. And I'm a firm believer in if everybody knows the law, it's better for everybody. So he was, not sure if he was trying to get a rise out of me, but I emailed him back and said, it's Merry Christmas early for criminals and their attorneys. And he laughed. But there are a few good things for the prosecution here, and we're going to get to what I think are the 4 really bright spots in the legislative session this year for prosecutors. Let's talk a little bit about vetoed bills. Interesting veto by the governor. He vetoed a bill that would have required prospective jurors to be addressed in court by something other than their first name and their last name. Could be a number, could be a first name. This is something that CDAA and law enforcement wanted, and the governor vetoed that bill. There were some good vetoes, however, and one of those good vetoes was a bill that would have required every youth, before being questioned by law enforcement, to have a consultation with an attorney in person, and it could not be waived. So he vetoed that as well, although I think we're going to see this again. In his veto message, the governor said that he wants to work with the proponents of the bill in the coming year to fashion reforms that protect public safety and constitutional rights. So I think we'll see this, again, the proponents of that bill claim that there is a high incidence of false confessions from juveniles, but in his veto message, Governor Brown did recognize that a lot of crime is solved by truthful confessions. So we may see this again. Bad bills that did not get through the legislature, did not even get to the governor's desk. One would have repealed our 3-year drug prior enhancement, Health and Safety 11370.2. Another one would have required that aggravating factors be tried to a jury, rather than just having them be sentencing factors that a court decides at a sentencing hearing. Fund bills, I always like to see what the legislature is spending its time on, and your taxpayer money. And one of the bills creates, for the first Friday in May, it's now called Space Day. And this bill encourages every resident, every business, every public entity to dim or turn off lights between 9 p.m. and 10 p.m. to reduce light pollution and enjoy the view of the night sky. So the first Friday in May, make sure between 9 and 10 you are dimming your lights. And the second fund bill, we now have a state fabric, and it is denim. And did you know that, according to the legislative declaration in this bill, that the history of denim jeans parallels the history of California? And I find that really interesting. And what they say is that prominent technology companies developed genius innovations while working in a garage wearing comfortable denim jeans. And also that the cotton industry is vital to the production of denim jeans. What is on the horizon regarding propositions, you might ask? Well, you were just assaulted a month ago with 17 propositions on the ballot. And so I wonder what else is out there. And you can always look at the Secretary of State's website, sos.ca.gov, and see what's out there, pending title and summary, see what's in circulation, see what's qualified for the ballot. The only one I saw that was in circulation at the moment is one that would provide jury trials in child custody cases. And then the one that's pending title and summary, you probably already heard about it, called Cal-Exit rather. It's the folks who want California to secede from the United States. But it's actually asked the opinion of the voters. The way it's worded is it asks you to vote yes or no, should California become a free, sovereign, and independent country. So it'll be interesting to see if that makes it onto some ballot in the future. And failing to qualify for the ballot was one that would have eliminated charter schools, and then a bunch of measures on recent gun laws, many of them trying to overturn some of the recent activity in the legislature and also some of the stuff that was enacted in Proposition 63, the Firearms Initiative. Let's go to page 6, and if any time you have any question about anything, feel free to ask me. Unfortunately, after I write some of this stuff, it was written so long ago, I forget what I really meant when I wrote it, so hopefully it's intelligible still. Let's talk about the State Act, the Stop Tobacco Access to Kids Enforcement Act. This is Business and Professions Code 29950.5 and following on page 6 of the digest. You already know this because I put this out in June when this bill became effective as urgent legislation. The legal age to purchase tobacco is now 21, so 18, 19, and 20-year-olds, except if you're in the military, cannot purchase tobacco, and of course that means retailers can't sell to folks under 21. And then Penal Code 308, I'm on page 7 now, which used to be the infraction crime for minors possessing, purchasing, or receiving tobacco or tobacco products, which was punishable by a $75 fine and 30 hours of community service, is now gone. See, part of the decriminalization of crimes committed by minors. So now the minor is not going to be criminally liable, it's the retail seller who is. Also on page 7, Business and Professions Code 23003.1 and following on page 7. This has to do with powdered alcohol. I never knew there was such a thing. But this prohibits the use, possession, purchase, sale, offer to sell, manufacture, and distribution of powdered alcohol. And apparently what this stuff is, it's small amounts of alcohol enclosed in rings of sugar. So when water or some other liquid is poured on it, it dissolves and frees the alcohol. And the concern is folks using it to further increase the alcoholic content of the drinks they're drinking, or it being smuggled into places where we don't want alcohol, places where alcohol is banned, like theaters, some theaters anyway, schools, and so forth. It creates two new infraction crimes, which I think the legislature might want to clean up this year. At least I have it on my list of errors and problems for now. New 25623 of the B&P Code prohibits all those things having to do with powdered alcohol, possessing, purchasing, selling, etc. But it punishes only selling, offering for sale, manufacturing, and distributing. And the second one, 25623.5, again prohibits all the same conduct, but only punishes using, possessing, or purchasing. So if you have this come across your desk, use whichever infraction crime has the punishment listed for the conduct that you encountered. One of them is punishable by a fine of up to $500. The other one is punishable by a fine of up to $125. Page 14, let's go over to the Civil Code. I'm not sure why that keeps happening. And I apologize for my voice, I'm getting over a cold, but there was no way I was going to cancel this. I would have to be dead or in a coma not to be here. My favorite thing to do of the year, even though it's a lot of bad news. In years past, I would tell the defense attorneys it was my favorite hour of the year when I got to train them, because it was all bad news for them and all good news for me. Civil Code 1714.24 is a new section. This immunizes collectors who have these drug take-back bins on their premises for both civil liability and criminal liability. So if they're doing all this stuff right in good faith, we can't charge them with a crime. They have to comply with state and federal laws. They have to notify law enforcement of the existence and location of their drug take-back bins. It has to be in a place where employees can regularly monitor it. There's got to be a sign on it saying what's allowed and not allowed to be put in it. And then if it's tampered with or stolen, law enforcement has to be notified. And the purpose here is to encourage pharmacies and other places to have these take-back bins by making sure that they're not going to be liable for criminally or civilly for doing the right thing. Code of Civil Procedure, this one really shocked me because if I hadn't looked at this weird budget bill, I wouldn't have seen it. This reduces, starting the first of the year in all misdemeanor trials, peremptory challenges from 10 for each side to 6 for each side. It's going to last for 4 years, and the Judicial Council is supposed to do a study on whether this speeds up jury trials. It is supposed to save time and money. Now, from what I read about this bill, the defense attorneys are vowing that it will take trials longer now because they will be exercising or moving more often to try to strike jurors for cause. At least that's from what I read about, that they're very upset about this. Although, as Jeff Rubin pointed out accurately, that they only need one juror to get a hung jury. We need all jurors to get a conviction. So interesting as to which side should be more upset about 6 jurors or 10 jurors. And maybe that's part of it, that we only have to convince 6 now and not 10. So maybe we do get some benefit out of this. Right below that, Code of Civil Procedure 415.21. This expands the list of people who may serve a subpoena inside a gated community by actually adding investigators employed by a DA's office. Page 17, constitutional provisions. If you read anything that I put out on the propositions, you already know about Proposition 57, but I just want to make sure that you're aware of this one. Again, nothing has changed as far as we know at the moment for anybody who is sitting in state prison. CDCR, the California Department of Corrections and Rehabilitation, has to adopt regulations before we know what's going to happen. We don't know whether that will take weeks or months. Those regulations will most likely be challenged by somebody, either defendants who think they don't go far enough or law enforcement who think they do go too far. So we'll have to wait and see what happens. But at this point, nothing has changed that I'm aware of. Page 22, the Elections Code, 2101 to 2212. Let's go down to page 22 here. And I've always was under the impression for many years that if you're a convicted felon, you don't vote. And that is not true at all. What's really the truth is that if you're a convicted felon inside a state prison serving your sentence, or on state parole, you cannot vote. But if you are a convicted felon sitting in jail serving your jail term, or a convicted felon on probation or mandatory supervision, or on post-release community supervision, or your felony conviction was 10 years ago, or you're pending sentencing today on your felony, you are eligible to vote. And this really just clarifies here in the Elections Code that folks who are on mandatory supervision and post-release community supervision can indeed vote. And what happened with this is when realignment was passed in October of 2011, the then Secretary of State decided that mandatory supervision and post-release community supervision were very much similar to state parole, and therefore those folks would not be allowed to vote. Secretary of State was sued. When the new Secretary of State came in, Alex Padilla, he withdrew the state's appeal in that case and said mandatory supervisees and post-release community supervision folks can indeed vote. So if anyone's in court talking about voting, that's the deal. If you're in state prison, or if you're on state prison parole, unless you're on those two things, you can vote. Let's go to the evidence code on page 29 and talk about 452.5. This is a nice change for law enforcement. You know, we're always seeking to prove prior convictions with certified court documents and things like that. And what 452.5 does is it clarifies or actually expands our ability to use court documents by saying that a copy of a certified conviction is admissible. So the court can email you something that's certified. They can fax it over. We can store it on our internal system and print it out for later use as long as it's certified. So keep that one in mind, 452.5. Let's go to page 31, evidence code. This is 1107.5. This creates a specific exception for the admissibility of expert testimony in a criminal case by either side, prosecution or defense, regarding the effects of human trafficking on human trafficking victims. And the way it's worded is the nature and effect of physical, emotional, or mental abuse on the beliefs, perceptions, or behavior of human trafficking victims. Now, what I say here is a little bit of my own editorializing. It does not appear to limit expert testimony to just human trafficking cases. You might have someone who was a human trafficking victim 5 years ago who's now a robbery victim maybe, and that's unrelated to that person being a previous human trafficking victim, but their experience as a human trafficking victim might be relevant to your case. And I think this might help you get some expert testimony in if that's important in your case. Next page, evidence code 1560 to 1563. This permits business records obtained by search warrant to be introduced into evidence with an affidavit from the custodian of records, just as we can do so with records obtained by a subpoena duces taken. So what this means is if you're getting a search warrant for business records, maybe you're at the pre-charging stage, you're investigating something, you're going to want to comply with these sections in getting your search warrant so that later on, if you do charge the case, and you do want to have those records be admissible, you can introduce them without having to go back for a second round of evidence collection. This is supposed to be a time saver for both businesses and law enforcement, not having to go back after serving the search warrant and getting the documents to do an SDT to get the documents all over again so they're admissible by affidavit. Let's skip to page 37 and go to the government code. And I am now at 7283 to 7283.2 on page 37. This is a very interesting bill. It's called the Transparent Review of Unjust Transfers and Holds. And what it does is, in a nutshell, is it attempts to limit the access that ICE has, Immigration and Customs Enforcement, to criminals in local jails. And this was kind of shocking to me because I hadn't really heard about this much. But what they do, what this says here is that if ICE, if the local law enforcement agency receives an ICE hold or ICE notification or ICE transfer request, the local law enforcement agency has to provide a copy of that to the inmate and to tell the inmate whether the agency intends to comply with the ICE hold. It also requires the agency, if it gives ICE a release date for the inmate, to give the release date to the inmate in writing and to also tell the inmate's attorney. It requires law enforcement to tell, if ICE wants to come in and interview somebody, to go speak to the inmate ahead of time and get written consent and explain to the inmate that he or she does not need to talk and can have an attorney present, etc. It also makes records relating to ICE access, including all communication with ICE, subject to the Public Records Act, so that anyone can inspect those records. And beginning January 1st, 2018, so a one-year delayed effective date on this part of it, this requires the local governing body of a local law enforcement agency, such as the County Board of Supervisors for the sheriff who runs the jails. If there has been ICE access of at least one inmate in the previous year, to hold a community forum to get input from the public about ICE's access to folks in jail. But what's interesting is the original version of the bill, which I often look at. I want to see how a bill got changed over time as it wound its way through the legislature. And this one was very interesting. Earlier versions of the bill prohibited altogether any school district, any California State University, any community college police or security department from providing ICE access to anyone, and requested the University of California to respect that. I guess the legislature can't tell UC what to do. The earlier version also conditioned a local law enforcement agency's cooperation with ICE on having a memorandum of understanding between that agency and the local governing body, like a city council or a county board of suits, with what the agency could and could not do. Now I'm going to go out on a limb here and say that I think we're going to see more bills like this year, as certain states, including California, concerned about the election of Donald Trump and what he might have planned for deportation of criminals. As we start to see the legislature session go on, I think we may see more bills like that that want to limit ICE access to criminals in jail. So we'll have to see if that comes about. But I would not be surprised if we see that. Let's look at the Health and Safety Code, page 550. Now, I mentioned this last year, it had a late effective date, and I want to mention it again because it was effective just a few months ago, and that was the End-of-Life Option Act, which allows folks to obtain drugs to end their lives if they meet certain criteria. So I just want you to be aware of Health and Safety 443.17 on page 50, because it does have associated with it 2 felony crimes. One is knowingly altering or forging a request for an aid in a dying drug, or concealing or destroying somebody's withdrawal of that request, or knowingly coercing somebody into taking an aid in dying drug. And of course, if some other more important crime or more serious crime is applicable, we can file that such as murder. Let's go over to page 53 and talk about Health and Safety 11350.5. This is one of those crimes, a new felony, that became law without the governor's signature. And this creates the new felony crime of possessing a controlled substance with intent to commit sexual assault. This one is the type of GHB that has not been approved under the Federal Food, Drug, and Cosmetic Act. It applies to sexual assault crimes such as sexual battery, rape, spousal rape, sodomy, oral copulation, and sexual penetration. I'm not going to spend much time at all on Proposition 64 marijuana. There are materials that I put out on Office Bulletin. If you're trying to charge a marijuana crime now, look at these few pages here, 1157 to 11360. It really depends on how much marijuana, the age of the person, whether the person has a particular felony prior, and so forth. But for the most part, there aren't any felonies anymore in the marijuana world, unless your suspect or defendant has a particular super strike type crime, has certain possession for sale or sale priors, or has hurt the environment by committing the marijuana crime in a certain way, or has used a minor to commit that offense. Unless you can charge the crime of conspiracy, so keep that one in mind as well. And again, no matter what your minor does, your juvenile does, anybody under 18, it's going to be an infraction crime, punishable only by a few hours of drug education and a few hours of community service. Let's go to page 61, 11361.8. Now, as with Proposition 47, which provided a section for people to come back to court to get their convictions reduced, no matter how old those convictions are, We have that for 11361.8 for Proposition 64. So I expect that there will be a lot of activity in the courts. A lot of activity in the courts for people coming back to get their convictions either reduced or dismissed altogether. So for example, somebody who was 35, who was, at the time, who was convicted of possessing 5 marijuana plants could come back and get that conviction wiped out altogether, because anyone 21 and over can now legally possess up to 6 marijuana plants, up to 1 ounce of marijuana, or up to 8 grams of concentrated cannabis. Many of the provisions are just the same as Prop 47's provisions. Some things have been resolved without having to litigate them, such as the issue we had that the Cal Supreme Court recently resolved in the Prop 47 area, which is if someone gets their case resentenced, can we go back and reinstate the charges that we dismissed or reduced pursuant to a plea agreement? And the Cal Supreme Court in the Harris case said, no, you cannot. Proposition 64 already had told us that we're not going to be able to reinstate dismissed or reduced charges. So resentencing cannot result in the reinstatement of dismissed or reduced charges. The court is required, upon receiving an application from a defendant, to presume that the defendant qualifies for relief or reduction or dismissal unless we prove by clear and convincing evidence the person is not entitled to that relief. And the unreasonable risk of danger to public safety is still with us as a standard, same as for Prop 47, which basically means, is the defendant at an unreasonable risk of committing a certain narrow class of crimes that we refer to as super strikes. And unlike Prop 47, Proposition 64 does not, or 11361.8 in Proposition 64, does not say that you cannot have a gun after your felony has been reduced to a misdemeanor or your felony has been dismissed. Prop 47 said that this reduction or dismissal or whatever does not allow you to have a gun. That is not in 11361.8. Let's go to page 63, 11362.1. And again, this is the section you want to look at if you want to find out what can I do now that I'm 21 years of age and older with regard to marijuana. You can possess, process, transport, purchase, obtain, and give away to somebody 21 years of age and older up to 1 ounce or up to 8 grams of concentrated cannabis. You can possess, cultivate, harvest, dry, process up to 6 living plants. And I'm not sure about that adjective living plant, or this adjective living plant. Does that mean you can possess 100 dead plants and nobody would care? I don't know. But it does say up to 6 living plants. You can smoke and ingest marijuana all you want, and you can have all the accessories as well. But you can't sell it to somebody, because then you run afoul of 11360, the health and safety provision. You can certainly give their marijuana to somebody 21 or older. Let's go to 11377.5 on page 72, and that is also a part of the same bill. They created 11350.5 that became law without the governor's signature, and this creates the new felony crime of possessing GHB or ketamine or flunitrazepam, also known as rohypnol, with the intent to commit sexual assault. Now, when Prop 47 passed in November of 2014, 11350, 11377, without anything more, became misdemeanor crimes. And the concern was, well, what if we want to charge a felony on somebody who was, possessing these drugs for nefarious purposes? So now we have these 2 sections that allows us to do that. They are both 1623 felonies, punishable by 1170H, jail time, not state prison time. Next page, 11.4, rather, 71.2 to 11.495. Okay, this is about forfeiture, which I really don't know anything about. It took me I probably spent a whole day on this bill, because I really had to do some research and try to figure out what the heck was going on here with this, because I really didn't know enough about it. But the bottom line here is that if you're trying to forfeit $40,000 or more in cash or cash equivalents, you do not need a conviction. If it's under $40,000, you do need a conviction. So $40,000 and more, no conviction required, standard of proof, clear and convincing evidence. Under $40,000 requires a conviction and proof beyond a reasonable doubt. We can no longer give our case to the feds, for the feds to do federal forfeiture, but we can do a joint investigation with them and share in that forfeiture if we're jointly investigating with them. So I'm going to leave it up to the experts in our office on forfeiture to be able to make more sense out of this than I did here, but I did devote 2 pages to it, so hopefully there's something that makes sense in there. Let's go to page 83, and that's in the juvenile ward section, juvenile delinquency rather. Okay, well, maybe I'm wrong about that. Pardon me while I figure out my roadmap. Yes, 208.3 of the Welfare Institutions Code on page 83. This is an interesting bill. It has a delayed effective date of January 1st, 2018, so it gives folks a time to prepare their procedures for this, but it limits to 4 hours the amount of time any minor or ward can be held in room confinement, in a cell by themselves, with no access to anyone except an attorney or the staff of the jail. We sometimes call this isolation or solitary confinement. It does not apply if the juvenile is in a court holding facility. It does not apply to adult facilities. It doesn't apply to a cell that's supposed to be a single cell. And it cannot be used to retaliate, to punish, or to coerce a minor. So it sounds to me the only thing you can really hang your hat on to do room confinement for a minor now in a juvenile hall is public safety or safety of the minor, safety of others, that sort of thing. And room confinement is defined as the placement of a minor or ward in a locked sleeping room or cell with minimal or no contact with persons other than correctional facility staff and attorneys. After 4 hours, the room confinement needs to be reevaluated. And they can only do the room confinement in the first place after less restrictive options have been attempted and exhausted. And then after 4 hours, staff have to return the minor to the general population or consult with mental health staff to develop an individualized plan, etc. So if you're doing juvenile work, take a look at that section. I imagine a probation will be working on this one over the course of the next year. And with Prop 57, you already know that Prop 57, I'm at WNI 602 now on page 85, has eliminated all direct filing of minors into adult court. So all of our mandatory direct filing and our discretionary direct filing is gone since Prop 57 passed. Right underneath that, 628 on page 85. This eliminates 4 of the 7 grounds. I'm sorry, I'm going to talk to probation about that. You don't need to know that one. 707. Let's go on. 707, and again, you know from the Prop 57 materials that the discretionary direct filing is gone under WNI 707, and all presumptions of unfitness are gone now under 707. Let's go over to page 107 and start on our penal code sections. And let's go to penal code 18.5. And this is in that category of the theme I talked about. One of the themes this year was preventing the deportation of convicted criminals. And this falls into that category. Let's see, 107. Penal 18.5. Now, this specifically makes retroactive Penal Code Section 18.5. Now, on January 1st, 2015, 18.5 became effective, and what it said was any misdemeanor punishable by a year in jail is really only punishable by 364 days in jail. And that is to try to prevent the crime from being deemed an aggravated felony under federal law for purposes of deportation. So we knew that applied to all pending cases, and it applied to all cases not final yet on appeal, but this makes it fully retroactive to all cases no matter their age. So anyone who was sentenced to a year in jail for a crime 20 years ago can come back to court and get that fixed to, say, 364 days in jail. But there's no guidance on procedural requirements, how it's supposed to work, or whatever. So keep your eyes open. You may be seeing some petitions for this. Penal Code 141. This is a felony crime that applies to prosecuting attorneys. Not something we see every day. Penal Code 141C is the felony crime of a prosecutor intentionally and in bad faith altering, modifying, or withholding physical evidence, digital image, video recording, knowing that it is relevant and material with a specific intent that the matter be concealed, destroyed, or fraudulently represented as the original evidence at trial. It is a felony, 1170H realignment county jail felony, 16 months, 2 or 3 years. So again, you have to have about 4 types of things here. You have to have intent, you have to have bad faith, knowing, and specific intent. And that's in 141C. 141A is still a misdemeanor crime of any kind, altering evidence, and 141B is the felony state prison crime of a peace officer concealing or altering or planting evidence. Interesting that the peace officers who plant or alter evidence are punishable by state prison. We're punishable only by county jail. So maybe there was a small victory in that. Maybe. 148, although if Prop 57 passes, you might be able to get out of state prison earlier, right, than if you did go to jail. So maybe that's not such a good thing. 148.5, new subdivision F in 148.5, and this is reporting a firearm to be lost or stolen, knowing the report is false. It's a misdemeanor crime, up to 6 months in jail, up to a $1,000 fine, normal misdemeanor punishment. Let's go over to 166. If you have someone who violates a 10-year domestic violence restraining order, the type of order we're able to get pursuant to 273.5J, where it's sentencing, no matter the sentence, the judge can order up to a 10-year restraining order for a domestic violence, or against a domestic violence defendant. This is no longer punishable under 166A4, up to 6 months in jail. It's now punishable under 166C, which is up to 1 year in jail. So that's a nice increase to violating that kind of restraining order. Let's go to 111 and talk about 186.34, 186.35. This adds, in the Penal Code, page 111, this adds adults to those persons, minors, who must be notified by law enforcement before they are designated as a suspected gang member or associate in a shared gang database. Now previously this applied to just minors, now it's everybody. So if police want to designate somebody as a gang member in a gang database, they have to give them notice ahead of time. The notice has to include an explanation for how you can get yourself out of the gang database, how you can contest that designation. Let's go to page 114, Penal Code 236.14. This continues the trend we're seeing the last couple of years in more and more sections that allow defendants to come back to court and have records sealed, cases reduced, records destroyed, etc. 236.14 details a procedure for a person who was arrested and convicted of a non-violent offense committed while a human trafficking victim to petition the court for relief from conviction, to get the conviction sealed, and to destroy the records. And it does define a non-violent offense as anything not listed in 667.5C, which is our violent felony list. So what that means is any human trafficking victim who commits a serious felony or a non-violent felony might be eligible for this kind of relief. They've got to establish by clear and convincing evidence that the arrest or conviction was a direct result of being a victim of human trafficking. Page 117, Penal Code 236.23. Again, continue our human trafficking theme here, Penal Code 236.23. This creates the affirmative defense I mentioned earlier about that applies to a human trafficking victim, but does not apply to a serious felony, 1192.7C, or a violent felony, 667.5C. if the human trafficking victim was coerced to commit the offense as a direct result of being such a victim at the time of the offense, and the person had a reasonable fear of harm. The person has to establish this by a preponderance of the evidence, and they can ask the judge to find the defense to be true at a preliminary hearing if they would like the judge to do so. And if they prevail on this affirmative defense, records are sealed, released from all penalties and disabilities, and they have permission to state on any application or whatever that they have never been arrested for or charged with a crime. 263.
What does that mean to say for a judge to be able to find if that's true? I mean, that barring is from going forward? Is that a no holding, or what is that practice?
Say that again.
What does that mean if a judge says, okay, I find your defense true to free them?
I'm wondering at that as well, because it seems to me that if I knew that I might have this defense coming down the road, I'm putting on my whole case at prelim. Unless I get the defense attorney's word that he or she is not going to be pursuing that at prelim. Normally they don't put anything on, right? So we put on our bare bones case, often Prop 115, testimony from a police officer. But if we don't have everybody there, and they put on a defense, we might be in trouble. So I found that really odd, that it shall be determined, and that's not my word, that's in the statute, shall be determined at the preliminary hearing if the defendant requests it. So if the judge finds the affirmative defense, the judge will then dismiss the case.
It's like a no hold.
And we'll be done. And then don't you think, Ruben, what else can the judge do? If the affirmative defense is found true, dismiss the case. We can then refile it and then come at it with a more thorough preliminary examination if we feel that's the right thing to do. If we feel the affirmative defense is valid, then of course we wouldn't refile the case. But
how can we refile it essentially?
Very odd, I know.
It allows them to make a factual finding of innocence and seal everything, so how can we refile it? We'll have to appeal it or take a writ.
So what you're saying is they might find the affirmative and then immediately ask for a finding of factual before we can refile.
Right, that's what I would do.
Okay, very good point, very good point. So, yeah, if we feel like this is going to be, if this could be a problem, we got to put on our whole case.
And there's no notice requirement. They have to notice they're going to be putting on that defense.
And there's nothing in the statute that says that. Yeah. So I found that really odd too. I don't know whether that was a sort of a drafting thing that somebody put in there really knowingly, really thinking about it, or what. I don't know. But something to watch out for. 263.1 on page 118. This sets forth the legislature's finding and declaration that, quote, all forms of non-consensual sexual assault may be considered rape for purposes of the gravity of the offense and the support of survivors. And it goes on to say that this is declaratory of existing law. And this is an example of a bill or a statute really not doing anything. It really doesn't affect anything. Yes, we all agree that non-consensual sexual assault is a bad thing. But the legislature felt the need to put this in a bill and to try to do something about it, when in actuality it really doesn't change anything. What's changed is the stuff we're going to talk about in a few minutes, where certain sexual assault crimes that were jail eligible are now state prison mandatory. That's a real change. And this is also an example of what we often see in the legislature, at least I've seen in the last 28 years doing these talks, that when a big case hits the media and there's public outrage, the legislature feels that it needs to do something about it. Sometimes they do really great things because of it, stuff that we could never get through if we didn't have the public outrage. And sometimes they do stuff like this that really doesn't do much. 290.012 to 290.45 on page 119, we finally have some resolution on this whole issue of what kind of internet identifiers do registered sex offenders need to supply when they re-up their registration, when they change residences or at their birthday every year and that sort of thing. And this bill attempts to conform those provisions to the Ninth Circuit decision in the Doe versus Harris case. So in a nutshell, in these first little 5 points I have here, it eliminates the requirement that they have to provide a list of internet service providers. It requires them to provide a list of internet identifiers actually used, not just identifiers that they established. It requires them to report a change of internet identifier within 30 days, not 24 hours. It prohibits law enforcement from disclosing internet identifiers, except except to non-law enforcement, except by court order. It narrows the types of sex offenders required to register their internet identifiers. So starting January 1st, 2017, anyone convicted of a felony on or after January 1st, 2017 has to register their internet identifiers if the court makes certain findings at sentencing that one of these three things applies. The defendant used the internet to collect private information about the victim of the crime. The defendant was convicted of human trafficking and used the internet to traffic the victim, or the defendant was convicted of felonies involving obscene matter, PC 311 and 311.12, and used the internet to prepare, publish, distribute obscene matter depicting a minor engaging in sexual conduct. So, and it's very interesting, the limitations put on law enforcement for this stuff. For example, 290.45 on page 120 now authorizes, of course, law enforcement, this is the existing law that we have right now, authorizes law enforcement to disclose information about sex offenders to the public when necessary to ensure public safety. That's why you can go onto a Megan's Law database and plug your zip code in and see how many sex offenders are living in your area. It permits a law enforcement agency to use an internet identifier from a registered sex offender that's submitted with their sex registration, only for the purpose of investigating a sex-related crime, a kidnapping, or human trafficking. So you couldn't use that internet identifier, however it might become relevant, to investigate a murder, apparently, which I found really interesting. Now 290.018 is amended to add a new misdemeanor crime, misdemeanor crime in subdivision I of that section. Somebody who's required to register as a sex offender and required to provide their internet identifiers, failing to provide those identifiers. Penal Code 308, we already talked about that. On page 121, the fact that minors are no longer criminally liable for purchase, receipt, or possession or use of tobacco, so that's no longer a crime. Let's go to page 123 and talk about 490.2. Here's one of the big bright spots in things that we got, law enforcement got this year. This was through a proposition, of all things. Proposition 63, the firearms proposition, adds to 490.2, this section shall not apply to theft of a firearm. Now 490.2 is a section we got in Proposition 47 2 years ago that basically says if you've got a theft, and the amount is not 950, not over 950, it's going to be a misdemeanor. The problem then became that a gun whose value was 950 or less, which most of these street guns are cheap, we couldn't charge that as a felony anymore. So no matter how you feel about guns and Governor Newsom and his Prop 63 or whatever, this is really great. And I really think this is great, that he recognized, whoever he had draft this thing, recognized that we really need to be able to charge the theft of a firearm as a felony, regardless of its value. So keep in mind, 47D2 is a state prison felony, and it's still a serious felony. 523, another new felony crime, an extortion-type computer crime related to the introduction of ransomware into a computer. It's in subdivision B1 of Penal Code 523, and it's the new crime of introducing ransomware into a computer system or network with the intent to extort money or other consideration. You don't have to actually get anything, but as long as you introduce into the system with that intent, you're guilty of this crime. It's a 2, 3, or 4 year felony punishable by jail time pursuant to 1170H, not state prison time. And of course, this is that kind of crime where somebody introduces this contaminant into your computer system. You can't get into it, you can't get to your stuff, and they want to extort money for you to give you the password or to delete the thing so that you can use your computer. So apparently it's been quite a problem for many, many people and many companies, and it was felt that the existing computer crimes we have in Penal Code 502 really didn't fit the conduct very well. Hence, we have this new felony crime of 523B1. 597.7, I included this one because it does immunize a good Samaritan from criminal liability who rescues a pet from a dangerous car situation. So, you know, there's been a lot of publicity, especially in the last decade or 15 years, about leaving kids in cars. Well, leaving animals in cars can be just as deadly, and this bill wants to encourage people to take action to free animals, but it's a little bit burdensome. You got to make sure you dot all your I's and cross all your T's. You got to make sure the car's locked first, and you have to have a good faith and reasonable belief that forcible entry is the only way to get the animal out of imminent harm. You got to contact law enforcement before breaking in. You then stay with the animal in a safe location, close to the vehicle, until the emergency responder arrives. You use no more force than necessary to enter the vehicle to remove the animal, and you immediately turn the animal over to the emergency responder. Kind of common sense stuff. But it's amazing how long some of these bills are, just to say, hey, if you're doing somebody, an animal, a favor, you're going to be okay with the prosecutors. They're not going to come after you. Let's look at page 126, Penal Code 632.01, another new felony crime. And really, it's interesting because we don't see, too many new felony crimes. Because usually the legislature will kill those in the Appropriations Committee saying they cost too much money, because there'll be too many people in jail or too many people in state prison. Well, this one is the new felony wobbler crime. It could be a felony, it could be a misdemeanor, of intentionally distributing a confidential communication with a health care provider that was obtained unlawfully pursuant to Penal Code 632, meaning it was obtained via a recording or eavesdropping of a confidential communication without the consent of all parties. It's a 16, 2, or 3-year felony in state prison, which was interesting. Of course, it has all of the usual exceptions to the recording crimes, for law enforcement, for campus police wearing body cameras, for obtaining evidence of a specific crime, hostage or barricade situations. But the real reason that we have this bill is because of the concern about the dissemination of those surreptitious video recordings that were made by the folks who exposed some of the Planned Parenthood activities in private conversations and with medical providers, apparently. These were done without the knowledge of doctors or Planned Parenthood people. In researching the bill, though, it was interesting. The opposition to this was intense. From the ACLU, from the California Newspaper Publishers Association, and from the Motion Picture Association of America, because they're very concerned about First Amendment grounds. So I expect this to be attacked by somebody on one of those groups, most likely on First Amendment grounds. In other words, if a video pops up, even if it's an illegal video, we want to be able to show it is what these groups are saying. So very interesting. 633.5, right below that on page 127, this adds human trafficking to the list of crimes like extortion, kidnapping, bribery, etc., for which it is permissible to record a confidential communication without the consent of all parties for the purpose of obtaining evidence of these crimes. In a long list of crimes, we're now adding human trafficking to that. PIN registers and trap and trace devices. I'm going to skip that because when we get to the Cal ECPA, Tom Flattery is going to come up and talk to you about those things because he is the expert on those things. Penal Code 640, as I already mentioned before, on the bottom of page 129. This eliminates criminal penalties for minors who do the fare evasion crimes. And there's only 640, excuse me, C1, C2, C3, the fare evasion crimes. Not the drinking, spitting, playing loud music, skateboarding, or smoking crimes. So those can still be charged criminally. But if you want to nail a minor for evading fare payment, misusing a pass or ticket, unauthorized use of a discount ticket, it's only via administrative penalty. The Public Utilities Code on page 130 here already allows any adult or any minor to be administratively penalized for this kind of conduct. But this is the first time we've seen some criminal penalties taken away in this area. Excuse me. What's interesting is apparently minors cannot smoke. No, nobody can smoke, I guess, on mass transit. So that would be one way that you can get a minor for smoking and still have it be a criminal infraction. Even if they're doing it on mass transit, you can cite them for 640. 647B, interesting changes here. We've already talked about on page 130, decriminalization of prostitution. We can no longer charge prostitution against any minor. We're only going to be charging adults with prostitution. It also eliminates the mandatory minimum jail terms that we have, 45 days if there was one prostitution conviction pled and proved, 90 days in jail for 2 or more. The most important thing to remember in charging is we now have 647B1, B2, and B3. Well, starting January 1st we do. And so B1 is going to be soliciting or agreeing to engage in an act of prostitution with the intent to receive compensation. So B1 will be used for the adult prostitutes, no minors, since minors cannot be charged with prostitution. 647B2 is soliciting an act of prostitution with an adult age 18 or older. This applies to the Johns driving by in their cars who are soliciting adult prostitutes. And 647B3 would be the Johns soliciting minor age prostitutes. So keep that in mind. There appears to be a movement afoot. Somebody wants to know how all these prostitution crimes break down. So somebody, I'm sure, will be gathering information on that sort of thing. And actually, it looks to me, in fact, the legislative history indicated, on top of page 132, I actually wrote that here, that they would like to collect data on the number of prostitution arrests for sellers of sex acts, buyers of sex acts from adults, and buyers of sex acts from minors. And in the future, they will consider increasing penalties for buyers of sex acts. Wouldn't that be something if prostitution became a felony crime if you're soliciting a minor? Well, I could see that in the future, maybe, if there's enough activity around there and the legislature feels that maybe minors are being victimized in this area, that we could see that. Let's go to page 133 and talk about 653.22. This is the crime of loitering with the intent, in a public place with the intent to commit prostitution. No longer a crime for a minor to do this. It does not apply to minors. Right below that, 679.11. This creates a procedure for a non-citizen victim of human trafficking to obtain a declaration of cooperation from law enforcement in order to help them obtain a T visa. Now, many of you are already familiar with the U visa situation. Now, U visas require a declaration of cooperation for that victim to be able to get their immigration status fixed. But the T visa doesn't require that, but apparently the Department of Homeland Security recommends such a declaration. There's a whole procedure here for that. And apparently the difference between a U visa and a T visa is a U visa could be anybody here who's a non-citizen who happens to be a victim of crime. They could come over here on vacation and something could happen to them. Or they were, somehow found their way here and were a victim of crime. A T visa is for somebody who was specifically trafficked into the United States. So that's the difference. In poking around the Department of Homeland Security website, I learned a few things. 799 is another huge bright spot in the legislative session this year, page 135, Penal Code 799 to Penal Code 803. This eliminates any statute of limitations for numerous sexual assault crimes. This is something that our own Chief Assistant, Jay Boyarsky, has wanted for years. We put forth proposals, never went anywhere, and thanks to Bill Cosby, I'm going to say, and the fact that there was so much awful conduct where the statute of limitations had run out on these crimes, the sexual assault crimes, this, I think, along with some public outrage over other stuff, spurred the legislature to do this. So now, all rapes except where the rape is committed under a false belief that the perpetrator is known to the victim, is no statute of limitations, all spousal rapes, all voluntarily acting in concert crimes, a lot of sodomies, a lot of all forcible child molests, 288A, regular child molest if there's substantial sexual conduct, many oral copulations, and many sexual penetrations. So previously the no statute of limitation crimes were those that were punishable by death or life imprisonment or involved the embezzlement of public money. And now we have all these sexual assault crimes. So, and there were some prosecutors, frankly, who weren't not entirely in favor of this because they're not looking forward to having to you know, maybe prosecute a 50-year-old sexual assault case, for example. But of course, you know, you don't file what you can't prove, and all we can do is, you know, what we can do with the evidence that we have. Yes.